Let's focus on another big story, a story that we have often spoken about. Actually, it's an issue that we have often spoken about, and that's the National Security Act and how this extremely stringent law is often misused and abused in our country. The story about detentions under NSA. Now, why am I again talking about it tonight? We have in the past highlighted how there were many instances of NSA being used against people randomly, people who are critics of the government, or people whose arrest would help you make a political point, which had absolutely nothing to do with public order or the national security. The law, many will tell you, is draconian, and I will explain to you why they say that. But first, let me tell you what has triggered this conversation yet again. This is because of an Allahabad High Court order that has now come in, where they have quashed a case under the NSA. 3 people were accused of cutting beef for selling purposes, and they were accused of doing this secretly in their house in Uttar Pradesh. And so these accused were booked under the NSA last year. The High Court did not see merit in the use of the National Security Act in this case. The High Court went on to say that they behaved in this way, or they were probably looking to sell this beef due to poverty, hunger, lack of employment. But this isn't a case of public order. It may be a matter about law and order and not public order. Detention of the accused without any material. And so they quashed this order and said, let these accused be released. Just a few days ago, there was another story that emerged from Manipur, where a journalist had been in jail for months together because of some Facebook posts. He was booked under the NSA and put behind bars. Now, why is this order so significant? Because it shows you that this law does get misused. It does get abused. And there are detentions which would otherwise be illegal detentions which are made under the NSA. It shows you the police and the administration can collude to act in such a manner, and the court in this case hasn't taken it very well. There's been a rap on the establishment. It shows you how states misuse a law. And of course, it's reignited the debate that I would like to have, because I don't believe we should have a law as draconian as the NSA. Let me say good evening to the panelists who are joining me on this conversation. SHARAT, senior journalist; DESH NIGAM, lawyer with the Supreme Court; Alok Lal, former IPS officer; and GEETA LUTHRA, senior advocate with the Supreme Court. Good evening to all of you. GEETA LUTHRA, if I can start with you, and I request you to explain to our viewers the various aspects which are there of the NSA law. How is it different from any other kind of an arrest, and the kind of rights that even an accused has under the law? GEETA LUTHRA, the question to you. I'm not too sure if my audio is through to her. GEETA LUTHRA, can you hear me? Good evening. Okay, I'm going to go back to her in just a bit. Mr. Deshratan Nigam, can you explain it to our viewers, the basics? How is it different from any other case where an arrest will be made?
Tanvi, in fact, there are laws in the Indian Penal Code and there are laws in the National Security Act, where the national security is threatened, public order is threatened. However, if there are, common laws in both National Security Act and the IPC, then the National Security Act will prevail over IPC, being the General Act and also later Act. That's what the Supreme Court says. Hence, the National Security Act will prevail over Common Law and Order Act as given in the IPC when you compare with the National Security Act. That aspect has been missed by the Allahabad High Court. Let me also point out, in fact, there are inherent contradictions in the order itself, where at one stage it says that it may fall under law and order problem, but does not fall under public order. However, subsequently they say that let me just read it out to you, that it was with great difficulty the authorities were able to restore the public order. So these are contradictory statements. On one hand, you are saying they were able to restore public order. Hence, it is in fact covered under public order as defined under National Security Act and does not fall under law and order. So this is the inherent contradiction that you have. The second aspect that they dealt with was whether they will do it in future or not. And they said there is no material on record. You know, in the case of preventive detention, you cannot say whether a person will do it in the future or not. There has to be a subjective satisfaction of the authorities in question. And since the person had already committed a crime, the beef was recovered from him. So there was a possibility that he can do it. Hence the preventive detention to prevent future law and order or public disorder problems. So court will never have a material before itself whether a person will do it in future or not. This is in fact based on certain intelligence input and you talk to the local people and general information which is gathered. So that will never be a part of your, record that would be there. So this is a very, although I agree this is a gray area. That gray area, but the Supreme Court says in a situation of a conflict between, say, a specialized act and the common law and order Indian Penal Code, then the latter act and the specialized act will prevail, and hence NSA would be applicable. And there are inherent contradictions in the order itself.
So the NSA, am I right in saying that under the NSA, you don't even have to be produced in front of a court or a district magistrate? In fact, you can be in jail for a period of 6 months, which can then be extended to a year without an actual court proceeding or a trial taking place. There is only one board that is set up to look into the matters, and statistics show that more often than not, they just go ahead along with, the decision of detaining somebody under NSA. Is it also correct, Mr. Deshratan, that under the NSA, the accused doesn't even have access to legal help, legal representation?
No. They have all the help. They can make, legal representation, and otherwise they can challenge their preventive detention in the High Court. And this is how
But in the High Court?
In the High Court, obviously, in the writ jurisdiction. You do it in the writ jurisdiction as in many other laws. So he invoked the writ jurisdiction where he said his fundamental right and legal rights are being violated. And therefore, that's the remedy in many situations where you approach the High Court.
Yeah, I mean, only if people are actually able to find that kind of legal support where people, somebody tells them that their only remedy is to go to a High Court in this case, or you are behind bars for 1 whole year without anybody having to explain that. Explain
so
to you.
Aid, Tanvi, 10 seconds.
Yes.
10 seconds. Legal aid is always available. They are always told for the legal aid, and every district has a legal aid cell where the lawyer is provided to them if they cannot afford or if they do not have an access to it. And in fact, I do some legal aid work also. So I'm aware of it as my contribution to the society. So all those things are available and people do. And huge amount of cases, I'm aware of Delhi High Court where a lot of legal aid work is being done, and as well as in district courts. So that access is easily available today.
Okay. Let me also bring in GEETA LUTHRA now. GEETA LUTHRA, many say that this law is draconian. One of the things that interested me about the National Security Act is that a person can be detained and the police doesn't even have to immediately tell them why they have been detained, what are the charges. Why would we design such a law?
So the fact is that if you're asking, is the law draconian? Yes, it's draconian. And the question here is that you sometimes need strong laws and you need them for purposes of terrorist crimes. You need it in cases where a very eminent and huge threat, not even eminent threat, a threat of the nature that it is extremely imperative to detain somebody by an act of preventive detention. It's an act, however, which is completely against the principles of Article 14, Article 19, and the right to life of a person. any such law to be muster has to be so carefully drafted that it cannot be open to misuse. And unfortunately, we are seeing misuse of the law every day by several governments because it is a dispensation which permits a party in power to not be transparent and to be opaque. Now, if it's being used for terrorist crime, then and to prevent terrorist activities, I can very well see that it may be required in some cases. But in cases of the nature which came before the Allahabad High Court, I feel in such cases you cannot be using preventive detention because then you are in fact taking away a person's liberty. And Mr. Nigam's statement that we have legal aid, I mean, why would anybody need the top guns of a country and engage them if the legal aid system was so much in place? My friend is doing legal aid, but he must be doing it in one case out of 50 that he may do. Many other people would not contribute that amount. You have to have great counsels to be doing and representing people, and right to freedom of one's liberty, right to life, are such strong fundamental rights that we cannot actually wash them away by saying that the law of preventive detention can be invoked in every other case. And I think it's time when the courts come down and ensure that preventive detention is not brought into place whenever anything is inconvenient or a person is kept behind bars without a right to bail. And this is increasingly, Supreme Court has been saying it in so many cases where the right to bail is denied by law and by legislation. Supreme Court is carving out exceptions that there is a right to bail. So I don't think my learned friend can say this. Preventive detention and its misuse is something so real in today's world that we have to guard against it. And your question is right.
Yes.
Do we need a National Security Act 1980 in these circumstances? And how do we ensure that it is not used for circumstances where it is not necessary, where the life-threatening situation of a terrorist offense or a security offense is not there?
Yes, in fact, the first time when we raised the aspect of National Security Act on the urban debate was actually when one of the Manipur journalists had been picked up and detained under NSA, and for months together there was absolutely no reprieve, no relief coming in for the journalists. This was a while ago. I'm not even talking about the latest instance. The latest instance was of a Manipur-based political activist who was detained, had to go all the way to the Supreme Court actually to get some relief. And what did he say? He essentially spoke about how how cow dung or cow urine isn't scientifically a treatment for COVID, and he was obviously commenting about certain political party leaders who had made that reference. He was picked up under the NSA, where you don't have to explain to him why he's been picked up. You don't have to explain to a court why he's been picked up and what's the case for several weeks before it actually sees the light of the day. Mr. Sharat Pradhan, the other widespread use has been in Uttar Pradesh, which is what the Allahabad High Court referred to, where this law is repeatedly used for, cow slaughter linked cases or beef linked cases.
Very true. We've seen how even journalists have been booked because they highlighted some misdeed of the government, misdeed of the local officials. For instance, there was a case of a journalist showing children being fed roti and salt, just roti and salt for the midday meal. And the fellow gets booked under the NSA. There's this case of Dr. Kafil, which you are showing also. Dr. Kafil, who is the man who pointed out how children were dying due to shortage of oxygen in Gorakhpur, in the Gorakhpur Medical College, which happens to be the constituency of the chief minister. He had to be in jail for months together before he could get bail. Now, the point that there have been other journalists also who have suffered on this account and have been booked under NSA simply because they criticize the government. And the government is and the government of the day is seen as a nation. So, say nation security is under threat if you highlight something which is wrongly being done under the government. Now, that is a tragedy. Even in case of the problem is, it is not a question of, it's good that the High Court has intervened, but imagine the trauma that the person goes through. He has to be in jail for months before he can do that. And it is not easy for any person to approach the High Court, or can't even dream about going to the Supreme Court. An ordinary man, Mr. DESH NIGAM might be talking about, I had good of him to be taking up such cases, but how many? That's the point. Here, I don't see many lawyers who opt for providing free legal aid. There are not many at all. So with the result, then the kind of lawyers who are provided to such victims don't end up anywhere. Is there any mechanism? I would, as a matter of fact, there needs to be an appeal to the courts also to see that when they grant bail or release a person who has been booked under such a draconian law, something should be done about those people who have booked him under that law, because they need some deterrence needs to be introduced. Otherwise, the person who has suffered, who is going to pay for it, for the months that he has spent in jail, for the third degree that he has received from the police?
Yes, okay. I know Mr. Nigam wants to respond, but if I can just quickly also bring in Mr. Lal, since he's not made his opening remarks and he's patiently heard everybody out. Mr. Lal, what is your view as far as the National Security Act is concerned?
The National Security Act is a very stringent law, as everybody has been saying. And therefore, it becomes very important that those who are using this law should be very particular about how and why they are using it. In my opinion, such draconian laws should never be brought into the picture unless there are absolutely acceptable reasons to do so. Actually, this act, when it came into being in 1980, had a dark history behind it. The dark history was 1818, the Bengal Control Act, which was brought in by the British. Then we had the Rowlatt Act in 1919, which actually led to a lot of uproar in the country. And you would perhaps recall that it also led to the Jallianwala Bagh incident. So this was Rowlatt Act. Then we had the Preventive Detention Act in 1950, under which some senior leaders, particularly of the Communist Party, were detained. Then we had MISA in 1971, which was so widely misused during the emergency. And all of us remember how terribly it was used across the board. And a lot of major leaders of the country also had to face the terrible music which such a law brings. And NSA in 1980 was brought at a time when we had the extremist problem in Punjab. We had militants very active at that time. And possibly there could be some justification for having a law like this at that point in time. But NSA was also described as an act which allows no vakil, which allows no appeal, and also doesn't permit any dalil. So no vakil, no appeal, and no dalil was the description of this act. So in a democracy where you bring in acts to control crime or whatever, you bring such an extreme act only when there is a necessity. we have to examine if currently we have the necessity for an act like this. Are we actually facing threat to national security of that extent?
Okay.
Are we actually facing some threat to the public order by and large? I think the Supreme Court had very beautifully explained the difference between law and order, public order, and the security of the state. So this was in the Ram Manohar Lohia case. So if you go back to that explanation, there are three concentric circles, the outermost being the law and order. So it does not necessarily include the next concentric circle, which is of public order. And the third concentric circle is of the security of the state. So the application of just a law and order problem to this act is not justified according to the Supreme Court also.
Okay, fair enough. So, you know, in the series of laws that you mentioned, the draconian ones and the reasons why many of them were brought in, we often actually discuss and debate the sedition law as well. GEETA, LUTHRA and Mr. DESH NIGAM have been very regular, you know, panelists on those conversations. Mr. Nigam, you wanted to make a point here. Go ahead, please.
You know, Tanvi, it's a very interesting situation. It's a preventive detention, and you cannot quantify as to how many crimes have been prevented. Some you can, and therefore it becomes a very complex question whether this law has been successful or not. You have given me statistics about exceptions, but we don't have statistics as of now that how many times this law has been successful. I agree about the gray area; it should not be misused. Therefore, whether this law is required, yes, it is required. But its misuse has to be prevented like in any other law, whether it is dowry laws or whether it is domestic violence laws or many other laws which are being misused. But they have stood the test of time and they have not been struck down because they're serving a particular objective that was to be achieved. Now, even this particular act since 1980 has stood the test of time and has not been struck down by the Supreme Court till now. Therefore, the law is needed, but its misuse has to be controlled, and certainly in this particular instance, I pointed out the inherent contradictions within the order itself. So I'm sure this can be easily challengeable in a court. On one hand, the court says that it does not belong into the domain of public order. It does not affect public order. But then it also adds, with great difficulty, police was able to, you know, bring back or control the public order. So this is highly contradictory.
Okay,
now,
so you've raised an
time,
interesting point. Let me ask you this question and then to GEETA, LUTHRA. For example, the Allahabad High Court order actually points out the fact, you're right, you know, and we did try to look for various larger statistics. Now, the court said out of the 120 detention orders between 2018 and 2020, between 2018 and 2020, there were 120 such detention orders, of which 94 were quashed. That's one statistic. I'm sure there are others. We also found another statistic which was a reply in the Rajya Sabha last year in 2020. And this one said by the government that 1,198 were detained under the National Security Act in 2017-2018. In 2017, 500 people were detained. In 2018, 697 people were detained. The government went on to say 563 of these are still under custody. This answer was given in 2020. Highest detained in Madhya Pradesh in 2017 and in 2018 UP also. 338 of these were from Uttar Pradesh. So my point is, Mr. Nigam, if the courts are pointing out how there is delay in procedure, how, you know, central government's response in following the procedure or even the state government's response in responding to the board leads to further extension of people being in detention, then isn't it a problem that we should be looking at and finding the solutions?
Yes, you know, there's no doubt. I said there is a gray area. And I agree there is a gray area. That misuse has to be checked. And there is no doubt about it. The police sometimes goes, you know, beyond its mandate. And they are able to become over-enthusiastic in trying to, you know, implement their political bosses, you know, desire, which may not have been expressed also. They try to be, you know, more loyal than anybody else. So all those factors have to be taken into account. And the statistics you are giving about UP, I'm not even doubting that for a moment. But the overall statistic that you have given, how many people approached the court and how many of their petitions were rejected also, that should also be considered, in fact, to come to some kind of a conclusion. So gray area nobody denies, and that is available in every law. That misuse we have seen, as I quoted you, and we need to find out a deterrence, as Satish Pradhan also said, somebody who misuses it. We don't have that punishment mechanism. It is, although the provisions are there, but they are rarely used. What is to be done to those people? However, this particular issue of preventive detention is a very complex issue because you cannot quantify, as I said, how many crimes were actually prevented because it's a preventive detention.
Okay,
It is in the question of a complex zone.
Yes. Okay. Two panelists want to make points. Sharat Pradhan first. Yes.
Well, I would like to know, is there any statistics on the number of cases of misuse? Because which must have been pointed out by the courts eventually. And I'm sure there must be a higher percentage of cases of misuse considering so many cases have been quashed. And I'm sure because police is always ready to be more loyal than the king, and political parties use this to serve their own ends, undesirable ends, I should say.
But I'm going to put Mr. Lal here, maybe in a spot, because this is a tricky question, Mr. Lal. We're looking for statistics, maybe difficult to differentiate between whether it was misused or they were just not able to prove whether it was justified preventive detention, may or may not have been. But in your experience, going by your experience, are there way too many of misuse cases?
Tanvi, I will not be surprised. I don't have the stats right now, but I'll not be surprised if a lot of these cases are actually made-up cases. Because, the basic problem with any preventive detention law is that when the person is arrested, he or she may not even be given the entire reasons for being arrested. You can keep from that person also why he is being arrested or she is being arrested. There are reasons to be recorded somewhere. The reason can be that in the interest of the nation, national security, we are not telling even the accused what are the grounds. So if you do not tell the grounds to the person, what will he defend and how will he defend himself? Number two is that in front of the advisory board, which is the first step in some kind of a judicial intervention, because the advisory board consists of 3 judges. Now, they may be High Court judges or fit to be High Court judges. They may not have served as a High Court judge. And the chief of this advisory board is a serving or retired High Court judge. Now, so you go before this advisory board without the help of a lawyer, because the law strictly prohibits the use of a lawyer. While Article 22 of the Constitution gives you the right to consult and being defended by a legal practitioner of choice. So while we are talking about the legal services made available by the government, those, I don't know if the quality is good enough, number one. Number two is that since you're not at all allowed to appear before this board with a lawyer, even if there is a lawyer available, you can't take him with you. And one more thing, the section 50 CRPC, which speaks of bail to an accused, it's not applicable here because the bail is not given. In no case of a preventive detention, bail is given. When you're not giving bail, you're not informing the grounds. And then also there is no FIR. You cannot challenge the FIR. There's no FIR at all. So the grounds on which you have been detained are somewhere hidden from you, no FIR. And then therefore the question arises that how does this person defend himself or herself? And in such a situation, just look at the common policeman. What kind of open ground that person, that policeman has to misuse this law. And if I may say so, I have maine apni rozi roti police se kamai hai, but I must say that police is not always clean.
Yes. Well, thank you for being so candid about it. Thank you for being so
Can
candid
I,
about it.
can I come in?
May I
Can
just
come in
add
for
one
10
thing,
seconds?
Tanvi? May I just add one thing,
Okay.
Tanvi?
Yes, just
You know,
yes.
just very briefly, during the Corona days, the Chief Minister of UP had gone on record to declare that anybody saying that any single person died of oxygen shortage when there were thousands or hundreds of people dying would be booked under NSA.
Yes.
Now that is the kind of threat.
Yes, that is the way.
Can I-
That's how the law is looked at and is often used. Yes, GEETA LUTHRA first, and then to Mr. Nigam. GEETA LUTHRA.
So the fact is, preventive detention by itself is an administrative act.
Yes.
And therefore, it's completely against the due process of law. The fact is, let's take this case. 14th August 2020 is when they were arrested. They have now got away with habeas corpus after exactly 1 year almost. Now tell me, how do we give them back the 1 year that all these people have lost? Firstly, they come under this cow slaughter. How can cow slaughter be an act which requires preventive detention? So they came under that act. Fine. There's an FIR registered. Then they put them under the Gangster Act. Then you put them under preventive detention. There is one other principle in law, which, the preventive detention law says nobody can be punished for the same offense twice. Here there is no offense. There is a fear of offense. And yet these people go once, get one FIR, get an FIR under gangster, and then have a preventive detention. This is not what preventive detention is meant to be taken care of. And therefore, I think it is time that this country becomes alive to the fact that every person who is arrested, even wrongly for even a single day, the state has to pay that price. Unless we do that, we will have our authorities, and I speak across board, we will have our authorities arresting with impunity because they know that there are no consequences.
Yes.
We will have counter affidavits and replies filed because there is no accountability if you file something wrong. And that is where you will actually cut at least 30% or 40% of litigation the moment we start spending time on processing somebody who makes a wrong affidavit and gives a wrong arrest.
Yes.
Particularly where there are cases of arrest. Every man's every single day liberty. And that was said in Arnab Goswami. It's been said, host of judgments, across board. You can't keep a person for a single minute extra or arrest him for a single minute unless you can justify it. Here the High Court and my friend Mr. Nigam saying there are infirmities in the order in definitions of law. Let's look at the broader picture. Can you justify preventive detention for an act of purported cow slaughter which has happened in the privacy of homes and where the news has spread and other people have protested outside? And that is why the court's so-called contradiction, that it happened in the privacy, but it may have created law and order outside. Now, if somebody and some reason law and order is created a situation outside, then people who are creating that situation also need to be careful that they don't take law into their own hands. But you can't punish a person for something like this under preventive detention. You already have 2 FIRs.
Yeah,
They
would
will
it really be preventive detention if the protest and the law and order situation was already brewing and had already been created? Just to add to the point you were making, as I go to Mr. Nigam, I want to also highlight what actually the court said about the delays and how that just adds to the pain for an accused under National Security Act and somebody who's been wrongly detained. And the court actually said, for the perusal of the counter affidavit filed by the Union of India, it indicates that an attempt has been made by central government to justify the delay in deciding the representation. And when the movement of file went from one desk to the other, which only further amplifies the bureaucratic red tapeism in the movement of files, without considering that the issue of detention is a priority and that the matter should have received prompt attention. There is no doubt that the state failed to discharge its obligation in deciding the representation expeditiously, and moreover, central government has not decided the representation till date, which is fatal and vitiates the detention order. This is the delay part that also needs to be fixed. But Mr. Nigam, to the point that GEETA LUTHRA was making, go ahead, please.
See, Tanvi, there is no doubt if there is a delay, accountability has to be fixed. And that is where the courts will come into the picture. You can't sit over the file for time immemorial and the person should suffer. I'm not talking about this particular case. Now, this particular case, that to public disorder, there is no doubt about it. And probably preventive detention would prevent further, in the future, the occurring of public disorder, not law and order. Please remember that. There is a distinction between law and order as defined under various acts and the public order. So this was specifically under the domain of public, and the person had committed a crime. They were selling beef. They were, and even it was in the private house. But when the news goes out, and it is a sensitive issue because cow slaughter is a crime in UP, which entails both fine and punishment. Therefore, this may lead to public disorder further because there could have been a history there that there was a possibility they could have done it again. So this preventive detention is a very subjective issue and gray areas would always be there. However, the delay aspect is considered. All these files, whether it is related to your National Security Act or any other files where prosecutions have to, respond, they have to do it within a stipulated time. They cannot be sitting over it. Thirdly, the advisory board where the matter goes is not there to punish somebody. It is there to actually scrutinize the act of the government. They are independent people and are sitting or a retired judge of the High Court.
Yes.
They are there to scrutinize, not to punish that person. In fact, to take that person out of detention to see whether he can be taken out. So it is not that kind of adversarial to the person who has been detained.
Yeah, no,
So
you're right there. Except that, the statistics largely show that they do not really rule in favor of the accused. It's largely to just allow the detention to continue for as long as the police really wants it to.
Then Tanvi, something is wrong with judges then.
I am completely out of time. Maybe we'll pick up on that point another day. Completely out of time. Thank you so much to our panelists for joining us, viewers. I think it's problematic. Preventive detention may be required in certain circumstances to ensure that public order, the larger public order, doesn't get disturbed. And so, in anticipation of what could go wrong, you detain certain people. But to say that those people do not have a right to be told why are they being detained, but to say they do not have every other single legal right, legal support, access that people do have under the IPC sections wouldn't and should not be a law that exists in our country today. And everybody that you speak to will say, yes, it is often, more often than not, misused and abused by various establishments. We've given you examples from Uttar Pradesh, Madhya Pradesh, even from the states of Northeast. Every political party would want to have such a law that works in their interest, helps them target people they want to put behind bars without offering an explanation. That's what happens with laws like National Security Act. A government may want to silence the journalists. A government may want to silence people who are highlighting issues, policy issues, problem issues, real issues on ground by using this act and simply claiming what you're saying is going to provoke other people. You're spreading lies against the government, and so without offering any explanation, we're going to put you behind bars for at least 6 months and teach you a lesson. When that becomes the mindset, then laws become a problem, and which is why these laws must be relooked at. At no point in a healthy functioning democracy should any state, should any government authority have this kind of an unfettered power to put somebody behind bars. No, not everybody in our country has good understanding of the law or even access or money to find themselves legal support that is required to get out of this kind of a problem. I hope someday various aspects of the National Security Act are looked at to make it more human, to keep the personal liberties and rights of people in mind as well. Thank you for joining us.